So there's something, a pattern that I've seen when it comes to those that are pro se or self-represented, is that they tend to file motions to recuse the judge, to get rid of the judge, right? And typically they say the judge is biased or the judge doesn't let me talk and everything else. I can tell you as a practitioner, 26 years now, only once did I consider a motion for recuse, and I decided against it because I knew it was going to hurt my case more. The chances are your state and your local rules are going to require that the same judge has to listen as to why they should be off the case because they're so biased. So good luck with that one. The problem of what I notice is a lot of times is that people don't understand the rules of evidence. And so they think they can just wave a piece of paper and say, but I got all the evidence right here, Judge, and this is over. And sometimes I'm going to file a motion to dismiss and attach the evidence and I'm done. It doesn't work that way. You would still have to have a hearing. The other side can go through the whole discovery process, and then maybe at that point the judge will consider a motion to dismiss. But to be at a trial just waving in the air, oh, here's all the evidence you need, this is proof that I'm right, that's not going to work that way. So when the judge shuts it down and tells the person you can't talk now, you can't interrupt because they're not following the proper rules of procedure, I always tell people the rules of procedure are 4 months in law school and the rules of evidence are another 4 months. And even then, it's hard to sometimes figure out how to get evidence introduced as a lawyer. So imagine a non-lawyer that doesn't have 8 months of training to begin with and is still not enough training. So be careful with your motion to recuse because you're probably making the situation worse. Judges have to hold pro se parties at the same level as the most experienced lawyers. A lot of times people say that doesn't make any sense because I'm not an experienced lawyer. So then the answer is, so we'll just have a lawyer with 30 years of experience has to follow the rules of evidence and civil procedure all the way through, but someone who has no experience can just forgive all that and forget it and they can forget the rules exist. That doesn't make any sense. So be careful with these motions to recuse the judge. Typically, it's not the best move to do. Typically, it's going to hurt your case more. And yeah, there are biased judges out there, like there's biased people and everything else. But typically, it's just that, not following the proper procedure, and then it looks like the judge is biased. My experience is judges are biased, but usually it's more likely that they're not. So be careful with your motion to recuse.